All right, we're back for what I expect to be a busy afternoon. And we've got several cases ready to go. Still have some moving to do before the end of the day. The first matter we're going to address is People versus John Elmer Fox Jr. He's here with his attorney, Mr. Paul Gibson. File number here is 2543SM. Defendant is charged with larceny under $200 and assault and battery. Abigail Stoll is here for the prosecutor's office. Ms. Stoll, what's the plea offer here?
Your Honor, in exchange for a guilty plea to the larceny less than 200, people are willing to dismiss the assault and battery charge.
All right. Mr. Fox, I've told you this at your arraignment, but let's go over it again. Larceny under $200 is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. Assault and battery is also a misdemeanor, punishable by up to 93 days in jail and a fine of up to $500. Let's take a look at this. Allegation is that you were at Sturgis last September and you stole a motorcycle ignition key that belonged to John William Miller, and you assaulted that person. So I don't know what the value of a motorcycle key is, but it's less than $200. That's the plea offer. They say you pulled up, took his key, and took off on your bike. Mr. Gibson, what's your client wish to do here?
I've conveyed the offer to him and he's indicating that he wants a trial.
All right, Mr. Fox, do you wish that trial to be in front of a jury or a judge?
Judge.
All right.
Not a jury trial?
No jury.
All right, you agree to waive your right to jury trial in that regard?
Yes, Your Honor.
That will make the case go faster. Ms. Stoll, do the people agree also to waive jury in this matter?
I would agree to that, Your Honor.
Do you know what you have for witnesses?
Just the officer and the victim.
The officer is Adam Kreitz. The complaining witness is Mr. Gregory John William Miller. Mr. Fox, you have any witnesses you wish to call?
The one that was standing there, Robert Marker, was standing there with us.
Robert Marker. We can subpoena him, Mr. Gibson, if you provide information on who he is and how to contact him. Otherwise, you'll be responsible for producing him if you wish to have him. I'm going to set this for a 2-hour bench trial. Bench trial goes faster. You get right to the evidence. You take the testimony. You don't have to pick a jury. You don't have to give jury instructions. And Mr. Fox has been around long enough that he's willing to just have it tried as a bench trial. Mr. Fox, you got a bunch of unpaid stuff. I don't know when you last made a payment. 690. You made a payment yesterday?
No, it's been a minute. It's been a while.
All right. I want you to start to pay on that.
Can do.
Do we have your Canara Street in Constantine?
Yep.
All right. So that's a good spot. How long have you been there?
It's mailing address. It's been a minute.
Are you working someplace?
Somewhat.
Tell me about that.
Packing and scrapping, pretty much.
Well, we'll set this for a bench trial, probably in May.
May I just explain something to the defendant on the record, for the record?
Yes.
Okay. Mr. Fox, you understand that you have a right to a jury trial. You understand that?
Yeah.
And in a jury trial, there would be potentially 6 jurors and the jurors would have to be unanimous in their decision. You understand that?
Yeah, I do.
And you're willing to waive your right to a jury to have just one judge decide your case?
Correct.
Okay, thank you.
I've known Mr. Fox a long time, and he's a man of his own mind. But I appreciate your expanding on the record. All right, Mr. Fox, you're good to go. We'll set this for a bench trial.
All right.
And,
Thank you, Your Honor.
I want you to make some payments before I see you next time.
I can do that. Thank you.
All right. You got Mr. Randall's in lockup. Is Mr. Gowan here?
Yes, Mr. Gowan's here too.
Ms. Limmerhart is here. What are we going to do with her?
Hi, Robert.
Hi.
We're not ready to resolve this case yet. There's still some discovery that we're waiting on. This was our first final pretrial. I don't know if you would adjourn the first final pretrial or just set it for trial. My expectation is at some point the case is going to resolve. But I just can't do it today.
Ms. Lemmerhart, why don't you come up and have a seat? I thought I cleared this all out. All right, we've had a pretrial, we had an arraignment, an attorney pretrial. I think we might have had 2 attorney pretrials. It's March 3rd. There was a misdemeanor offer. This was originally charged as a felony. It was amended to a misdemeanor. And we left it on for, oh, that was our other case that's been bound over to circuit court. This case, we were here on March 3rd and we set a pretrial for March 10th with the other case. And we discussed it again on March 10th. Thought they had an agreement. I wasn't completely on board with it. The agreement was to dismiss the felony charge, which has been bound over to circuit court, plead to this charge with no jail. And I wasn't on board with a solid recommendation of no jail because of the baggage that Ms. Lemmerhart has. So the deal didn't go through when we set the matter for final pretrial today. What additional discovery do you need?
There's video footage from Walmart, and that's not in the file.
What do we know about that?
Well, Your Honor, I noticed that was missing today. I believe there's some video footage from the self-checkout, which is weird.
If
Well-
I could say that Ms. Stoll has, I believe that she's been diligent in trying to find everything. I don't think that there was a problem that went on. It's simply, even the case is still relatively new in a way. Even though we were here on March 10th, we all thought that we're working towards resolution. We still are thinking that we're working towards resolution, but it's not proper for me to have her, Ms. Lemmerhart, potentially plea in a case if there's video evidence that really should be viewed before we go forward.
I don't dispute that. I would have hoped we would have got it between March 10th and April 9th, but Walmart has very high definition videos shining directly down on the checkout lanes. And I'm not sure if the affidavit. Do the police have the information, Abby?
Yeah, according to the police report, it says that the video footage was saved to the server.
Well, frankly, everybody should have had it before now, but I understand Miss Montag's position. That's what a conscientious attorney does, make sure they look at all the evidence first. Let's set another last pretrial rather than a trial. About a month out. I will tell you, for all your purposes, if she does enter a plea, I'm inclined to ask for a pre-sentence report to figure out what to do here. Are you available Thursday afternoon, May 21st at 2?
Oh. Yes, Ron. I'm laughing because I have a blood donation appointment, but yes, I can make myself
Well-
available.
All right, well,
Yes, I can be free.
all right, 5/21/26 at 2 p.m. At that point, we'll be over in the other building.
Okay.
today is you're here on our last afternoon in history in this room.
That's
And
actually,
so you can tell your grandchildren about that. At any rate, Ms. Lemmerhart, stay in contact with your lawyer. Don't get in any more trouble till we resolve this. The circuit court case is still up there pending this one. So I'm not faulting anybody. Everybody needs to see that video, but apparently the Three Rivers has it. They need to get it and get it to her, and then we'll see what we're gonna do on May 21st at 2:00.
thank you, Judge.
All right.
In this courtroom session, the judge begins a busy docket by handling the case of John Elmer Fox, Jr., who is charged with misdemeanor larceny under $200 and assault and battery for allegedly stealing a motorcycle key and assaulting the owner. The prosecution offers to drop the assault charge if he pleads guilty to the larceny, but Fox rejects the deal and chooses a bench trial, formally waiving his right to a jury. The judge schedules a 2-hour trial, discusses witnesses, and reminds Fox to start paying outstanding fines while noting his unstable work situation. The court then shifts to another defendant, Miss Lehard, where proceedings stall due to missing Walmart surveillance footage that could be key evidence. Her attorney argues it would be improper to proceed or accept a plea without reviewing it. The judge agrees, postpones the case for another final pretrial about a month later, and stresses that all parties must review the video before moving forward, while also indicating that any plea might require a pre-sentence report due to her prior record. Overall, the hearing highlights routine courtroom management, balancing plea negotiations, trial preparation, and ensuring fair procedure through complete evidence review.